Hello, I'm David Shulman, and this is my partner, Jill Ginsberg. We're Ginsberg Shulman, an estate planning, probate, guardianship, and trust administration boutique law firm right here in South Florida. Today, we want to walk through what the probate process in Florida actually looks like, because there's a lot of frustration around probate that comes from not understanding what's happening or why it takes the time that it does. Jill?
When someone dies owning assets in their individual name, Florida law requires a probate process to transfer those assets. Probate is not a single event. It's a series of required legal steps, many of which are driven by statute, not by the court or by the attorneys. So, David, when does probate actually start?
Jill, probate begins by opening a court case in the county where the decedent, that is the person who passed away, lived. The court appoints a personal representative, what most people call an executor, who's given legal authority to act on behalf of the estate. That appointment is critical. Until the court issues those letters of administration, no one has legal authority to access accounts, sell property, or deal with creditors. Once the case is open, though, Florida law requires that certain notices go out. This includes a notice of administration and notice to known or reasonably ascertainable creditors. This is not optional, it is required by statute. Jill?
One of the biggest timing issues that people don't realize is the creditor period. In Florida, once the notice to creditors is published, creditors generally have 3 months to file claims in the estate. During that time, the estate simply can't distribute everything and move on. The waiting period exists to protect both the estate and the beneficiaries, so debts are handled in an orderly way and don't show up later. Now, while that's happening, the personal representative is also required to identify, secure, and inventory probate assets, things like real estate, vehicles, bank accounts with no beneficiary, or business interests. David, what happens after the creditor period?
Jill, after the creditor period expires, the estate can then resolve valid claims, pay expenses, and prepare for distribution. But even then, Florida probate isn't instant. Assets have to be properly transferred, deeds have to be recorded, and accounts have to be retitled. Sometimes court approval is even required before property can be sold or distributed. And if there are disputes, either over creditor claims, beneficiaries, or the personal representative, probate can take even longer because the court has to resolve those issues.
This is, David, is where we often see confusion. People think probate is slow because someone isn't doing their job. In reality, most delays are baked into the system by design. Probate is meant to be deliberate, not fast. It prioritizes accuracy, notice, and fairness over speed. So, David, what's the big takeaway for people watching this?
Jill, the takeaway is that probate in Florida is a process with guardrails. It's not a shortcut, but it's not meant to be. Sometimes probate can be minimized or avoided with proper planning, but oftentimes it can't, even especially with real estate or complex assets. And sometimes probate is actually the safest way to make sure everything is handled correctly, that the creditors are paid, and the proper beneficiaries receive what they're entitled to. The goal shouldn't be to fear probate. The goal should be to understand it and plan with it in mind. Jill?
And that's why, David, good estate planning isn't just about avoiding probate. It's about knowing when probate is required, how it works in Florida, and making sure that there are no surprises for the people left behind. Thank you very much for watching this video.